Glen Oaks Village owners versus City of New York.
Good afternoon, Your Honors, and may it please the Court. Amy McCampbell on behalf of the City Appellants. Your Honors, I'd like to reserve 4 minutes for rebuttal.
4. Thank you.
Your Honors, this Court should reverse and dismiss plaintiff's implied field preemption claim. As this Court recognized in Jansen, implied field preemption requires a showing that the legislature clearly evinced an intent to occupy a field to the exclusion of all others, and here the Climate Act does nothing of the sort. To the contrary, the Climate Act expresses the legislature's all-hands-on-deck approach to climate change, welcoming contributions from all levels of government, including the local level.
Counsel, it seems to me the appellate division was really focused on sections 11 and 10 of the Act, right? So how do you read those two sections together in a way that avoids a preemption problem?
So those two sections, first of all, the sections are savings clauses. So by the plain language of Section 11, it says nothing in this Act relieves anyone of the need to comply with other local laws and regulations. So plaintiff's reading flies in the face of the plain language of the statute because they're arguing that when you read Section 10 with Section 11, it relieves them of the need to comply.
So then why do you have Section 10? What does Section 10 do then?
So those two provisions, they're
But let's stick with Section 10 for a second. If your reading of Section 11 is correct, why do you need Section 10?
Sure, they're doing different things. They have different language and they're achieving different aims. So Section 10 states that all state entities, broadly, to the extent they have pre-existing authority to take greenhouse gas emission reduction measures, which is a broad term, they retain that authority under the Act. And that makes sense that that provision was included because the Act includes a lot of new authorizations to state agencies and entities. We see Section 8 authorizes every state agency to promulgate regulations to reduce greenhouse gas emissions. Section 7 requires all state agencies.
So your reading of that would not include then what's in Section 10, which would be nothing in this Act shall limit the existing authority of a state entity to adopt and implement greenhouse gas regulations. So your reading of Section 11 would not include what's in Section 10.
Yes, Your Honor, there are different provisions. They're achieving different things.
But you seem to have a very broad reading of Section 11, so I'm trying to understand how, given your broad reading of Section 11, you would need Section 10.
Section 10, again, is just clarifying that state entities, to the extent they have existing authority to take measures to reduce greenhouse gas emissions, nothing in the Act removes them, replaces that authority. The authority
I thought you were arguing that measures might include steps other than laws and regulations. Is that right?
Yes, Your Honor.
And so it sounds to me like perhaps there's some overlap between the two sections, even if they're not redundant of each other under your reading. In other words, 10 covers some actions that might be taken. You give examples of a couple that wouldn't be covered by 11, but wouldn't there also be perhaps some overlap between measures such as laws or regulations that might be covered by both 10 and 11?
I think regulations in Section 11 might also perhaps include some measures in Section 10, but plaintiff's reading also has this kind of overlap as well because they argue that Section 11 is broader than Section 10. And both of the provisions, what they're really expressing, again, is this all-hands-on-deck approach to climate change that we see throughout the statute. We see it in the legislative findings, and we see it in the multiple provisions throughout the Act referring to local action.
Do we know what gave rise to Section 10? Was there particular concern that measures other than laws or regulations might somehow be viewed as, the authority to take those might somehow be viewed as extinguished by the statute?
Well, there's nothing in the legislative history that really speaks to these two provisions, but I think what's telling is that there's nothing in the legislative history that shows that anyone viewed them as having this kind of preemptive effect that plaintiffs are now claiming.
They also seem to use a different framing. That is, the first one, 10, talks about a limit on the authority of the state to promulgate laws, and 11 talks about compliance of people who are subject to the laws, not about the authority to promulgate laws. So they seem to operate from different directions.
Your Honor, we agree completely that they're...
Then would no one be allowed to promulgate laws under the first one other than the state? So if 11 doesn't cover promulgation and only 10 does, then local governments couldn't promulgate, but that if they had existing laws, then you would have to follow them?
So Section 10 says state entities taking measures to reduce greenhouse gas emissions, which is, again, is a broad standard. And I
I
think
understand that argument from Judge Halligan, but what, in response to the Chief Judge's argument, position or question, what is measure and law and promulgate and follow? So 10 and 11, it seems to me if you take that reading would be the existing laws you have to follow, but if you want to make new laws, then you have to be a state entity.
I don't agree, Your Honor, because Section 11 doesn't say anything about existing laws. It's Section 10 that says that state entities retain their existing authority. Section 11 says that everyone needs to comply with other applicable laws and regulations, whether they're pre-existing or not. And again, these provisions, they express the same idea, which is that everyone needs to comply with regulations and measures and laws.
Counsel, I don't know that there's any meaning in the distinction between pre-existing and newly promulgated laws. The question originating from the chief, as I understood it, was that one section deals with compliance and another section deals with promulgation. And in the promulgation section, it is limited to state agencies.
But Section 10 is not about promulgation because it's not about regulations or laws. It's about measures. So everyone can take all.
I thought your argument was that it could include things other than promulgation. I understand that from the line of questioning with Judge Halligan. But are you saying that it excludes the promulgation of laws, regulations? It just doesn't apply to that situation?
It's broader. It's that all state entities can continue to, state entities can continue to take all measures to reduce greenhouse gas emissions. And again, we see in the legislative.
But not localities.
Well, localities already have pre-existing authority to regulate in this area. We have authority to regulate local air pollution and buildings, and nothing in this act takes that away. And it's significant, as this court noted in Jansen, that there's no express statement of preemptive authority anywhere in this law, particularly because it was passed shortly after Local Law 97.
Why wouldn't that also apply to state agencies who had pre-existing authority? Why would you have to signal them out in Section 10? Why
Again,
wouldn't that same
the law
thing apply?
grants new authority to different state agencies, including all state agencies.
But I think your point being, with respect to local authorities, it didn't interfere with their existing authorities. So I would assume the same would apply to state entities. It wouldn't interfere with their existing authorities either.
I mean, you could critique it perhaps as a belt and suspenders approach, but I think what the
Or you could
legislature
critique
is.
it as a redundancy, which would be problematic.
I don't think it's redundant, Your Honor, because it's clarifying, again, that everyone really needs to play their part, take a role and play a part here. Again, it's an all-hands-on-deck message, and we see that in the legislative findings.
Let me ask you an abstract question. Suppose the legislature passes a new law, governor signs it. Is the test for determining whether that law displaces some existing state law different from the test for whether it preempts a local law?
I'm not sure, Your Honor, because we're focused on the local law at issue here. I'm not sure what the test would be for a state law. But again, we see multiple indications in this law that there's no preemptive intent from the legislature. We see the legislative findings, which refer to the need for complementary action from other jurisdictions. The legislative findings also note that there's a need to rapidly reduce greenhouse gas emissions in order to avoid the worst impacts of climate change. And a finding of implied field preemption here would go against that very purpose by prohibiting any localities from taking the kind of actions that are necessary to reduce greenhouse gas emissions.
To go back for a second to the Section 10, Section 11 discussion, it seems to me they're also very different in scope, aren't they? Section 10 applies specifically to state entities, and the compliance point in Section 11 looks to me to sweep as broadly as one could, person, entity, agency, so both private and public.
But isn't that the problem? Why do you need the specific if you have the general?
I think they're doing different things. One of them is about the authority of state entities, and the other one is about the need to comply with laws. And plaintiffs' reading, what they're really trying to do is find preemption by negative implication, by transposing phrases from one provision to another. And that's really the furthest thing from a clearly evinced preemptive intent. Their reading also violates the last antecedent rule, as the plaintiffs concede. But the last antecedent rule, qualifying words and phrases should be applied to the words immediately preceding and not to others more remote. And plaintiffs are arguing that we should read the other all the way back to Section 10 to refer to other measures than greenhouse gas emission
And
reduction.
is that a natural way to read the statute? or interpret it?
No, Your Honor, because the the natural antecedent is nothing other than other laws and regulations besides this act. That's the antecedent in Section 11 itself. So they're reading, again, it goes against the plain meaning of Section 11. There's no indication that anyone in the legislative history had this interpretation or this view of these provisions. It violates the last antecedent rule. It also doesn't make sense when you look at the language of these provisions more granularly, because they're arguing that Section 11 shows that local action is preemptive. But Section 11 doesn't just speak to local action, it speaks to local, state, and federal. And for two of those three categories, their preemption theory makes no sense at all. So again, these provisions are doing different things, they have different phrasing, and there's no preemptive intent evinced through these provisions, much less clearly evinced preemptive intent.
Can I ask, it looks to me like the statute contemplates or requires the promulgation of regulations over time by DEC, yes? So what has the city's approach been going forward? Is the city continuing to promulgate regulations of its own independent of what DEC is doing? What's the interplay between the two?
So the city, I see I'm out of time, but if I can answer your question, the city, Local Law 97, set standards for emissions from buildings, and it was passed first. Then we have the Climate Act passed after Local Law 97, again with no preemptive statement of intent. The regulations that DEC has issued pre-proposal regulations that build on Local Law 97 and take into account Local Law 97. And we cited the DEC slideshow in our brief on that point. So DEC is building on the city's local law, which already existed and which already sets standards for large buildings within the city. Thank you, Your Honors.
Good afternoon, Your Honor. May it please the Court. Lee Nathanson, representing the plaintiff's respondents. This appeal is not about which side presents the most plausible or the best reading of the CLCPA or its savings clauses.
Do you think that the word "other" can really bear the weight of your interpretation?
It has to mean other than what? If the last antecedent rule were the only governing principle that we could abide by here, and that it meant other than the act, then this section of the CLCPA, Section 11, would be so broad, it could be included in every statute to say, by the way, here's this law that we're passing, other laws still exist, other laws than this act. Here, we're looking at two clauses next to one another. One of them reserves the right for state entities to promulgate laws regarding one specific area of what the CLCPA does and what Local Law 97 does, which is...
Do the two clauses do the same thing? And if they don't do the same thing, is it logical to read them the way that you are suggesting?
They do the same thing in the sense that they prescribe what roles actors within the state and within localities are able to do in the context of the CLCPA. One of the provisions, Section 10, deals with promulgation of regulations, which is something that we believe the legislature meant to reserve to the states.
It's not limited to regulations. Otherwise, they would have said that.
It's not limited to regulations. It's limited to measures in the greenhouse gas reduction measures. So yes, it's limited in that way.
But it could include, I assume, something like putting solar panels on the roof of a state university building or something like that, yes?
Section 10 wouldn't speak to that because Section 10 is a savings clause for measures that state...
My point is, Section 10, it seems to me, but if you have a different view, please let me know. Section 10 seems to me to confirm that should a state entity, I'm just picking a state university as an example, want to take a measure like that, that it is free to do so and that its authority isn't affected by the statute in any way. Is that fair?
I think that's what Section 11 does, because Section 11 provides nothing in this act shall relieve any person, entity, or public agency.
That's a compliance question, I think, as opposed to an authority question.
In other words,
the second-
Section 11 might not have any law that requires solar panels.
Well, Section 11, what I think Section 11 does, and the second half of it says, with other applicable federal, state, or local laws or regulations, including state air and water quality requirements and other requirements for protecting public health or the environment. So I think Section 11 would speak to the solar panel measure because it would allow that. It would not preclude.
But there would have to be a law that mandates solar panels.
Yes, a pre-existing law or a subsequent.
Whereas 10 would not require that.
10 would not.
Only requires a
10 doesn't-
particular, only requires the state entity have authority to take a particular action, not that it's mandated to do so.
Correct. What Section 10 does is limit authority with respect to one particular type of measure.
Wait, Section 10 limits authority?
Well,
Section 10 says nothing in this act shall limit the existing authority. So where's the negative implication of a limitation you're reading
the
in there?
negative implication is that there's one group of entities, and that is state entities, that are not limited by Section 10. Other
So you're
authorities-
saying you read what's covered by Section 11, you're reading the two together, I take it what you're saying. Can I ask, one of the things I'm struggling with is your adversary says that if the local law provisions are deemed preempted, that it will materially affect compliance, just in terms of the numbers, with the targets. And so it seems to me there's an argument that if in fact the legislature intended this to have the broad preemptive effect that you suggest it does, that it might have said so more explicitly or grappled with the fact that this would eliminate these measures which achieve some significant numbers. What's your response to that?
This gets to the crux of our argument on appeal, which is that plaintiffs have not had the opportunity to develop a record, nor has the city, as to what measures and what other information might be relevant to the question of what the legislature did mean here. And of course, both sides are saying.
I'm not sure, maybe you can explain this. I'm not sure what it is that would be benefited by discovery. Usually a question about preemption, I believe, the courts resolve as a matter of law, and you look to what the statute says and what the legislative history says. But there's not generally, I don't think, factual development that takes place in a case like that.
That's not quite right. So
are there examples where that's happened?
Well, the Merck case, which the city distinguishes on its facts, but we cite for the principle that courts, even on a question of law like a preemption question, often need to resolve ancillary factual disputes. It's a basic
Well, what would those
legislative
be here?
Yeah,
Let's
what
say
would-
you're right. What would those be here?
Well, I think that we would have to look to legislative records. Both sides cite a ton of information that is outside the record, and indeed,
I'm
the
sorry,
city-
what are legislative records? Are you talking about legislative history? Or
Well, there are public records that evince the legislative history here. The city has mentioned that those records don't really say anything one way or another about how Section 10 came about and how Section 11 came about. Almost all of the cases that the city cites on questions of preemption were decided on summary judgment, not on a motion to dismiss here. Sometimes the records in those cases have included expert testimony about exactly the type of question that Your Honor is asking. What are the practical effects of this reading versus that reading, and how does that—
It's a question of legislative intent. I mean, that is the touchstone of preemption, I think, right? So I'm just struggling to understand how some discovery process would bear on the issue. And it seems to me that one could probably deduce, just as a matter of common sense, that given the requirements laid out in the local law, that it would have some effect on greenhouse gas emissions. And so my question is just, if that's correct, and deeming it preempted would make it more difficult to hit the target, why wouldn't the legislature have grappled with that more explicitly if it meant for it to be preempted, as you say it does?
Sure. 2 points. I think the assumption is not necessarily correct, and I think we can see in the developments, even since the filing of this case, that Local Law 97 is now looking to be at odds with the CLCPA, including, for example, in the fact that the city is going to be instituting penalties on building owners for their failure to, for example, convert to electric within the time period set forth in Local Law 97, the city's going to be collecting that revenue and putting it into the city's general fund, not toward environmental causes. And then those building owners are going to be paying their money toward penalties instead of toward taking measures along the lines of what they've been doing in the past to try
That's
to.
a disagreement with the policy issue. Let's go back to Judge Halligan's question.
You're absolutely right that it is a disagreement with the policy issue, and the city argues that the policy questions are not relevant. But they are relevant, and this is exactly the type of record that many of the cases that the city cites have developed. The policy questions of, well, what would really happen here if you read the savings clauses as creating preemption versus how.
So let me ask it a different way. Let's, again, assume that we agree with you. Then what would be the state of, maybe that's not the best word. What would then it look like in New York under your scenario if this preempts 97 and other local initiatives?
It would look exactly like what the CLCPA contemplates, which is that the city and other municipalities will have a role, a significant role, in working with the state and the expert bodies that the state has entrusted to develop these regulations, or these standards, including the greenhouse gas reduction measures. The CLCPA says a lot about what cities are going to do and what role they will play, including in reporting information, advising on how the CLCPA.
And is there any language in there that says that the localities cannot take a different path? Is there anything that expressly states that localities can and must only follow in accordance with this statute and what the body, the council decides?
There is only the language of Section 10 that expressly reserves that right to state entities. So it is not a prohibition, but it is an exclusive reservation of the right to adopt and implement.
So if we disagree with you about Section 10, you lose, yeah?
If you disagree
If we're not
about Section-
persuaded by this particular reading that you're advocating for.
Well, not on the posture of this appeal, because again, we're on a motion to dismiss standard. And so the city is correct that the standard that we will ultimately have to prove on a record in the trial court is that the state legislature clearly evinced an intent for the local laws to be preempted.
What would be your
for
other
now-
argument on field preemption?
Well, the
I
argument.
thought this was your argument.
Yes, this is the argument on field preemption, but I don't think the First Department correctly held, and I really haven't seen anything in the city's papers on appeal to dispute this. All the First Department held was that our reading is plausible. And the city throws.
And if this court decides otherwise,
If this court
isn't then the
decides.
field preemption question put to rest?
If this court decides that on the merits, that reading is inherently implausible, then yes, we lose. But the standard is
Or
much.
decides that the correct reading is the reading that your adversary, or some other reading that's
Well,
not favorable to you,
if the
is the
court-
correct reading of the statute?
Well, there's a nuance there. It doesn't need to be that their reading is correct. It has to be that our reading cannot be correct under a notice pleading standard and based on any potential record that we could develop. We could.
Again, you're back door to this question that Judge Halligan asked, which is what record is there to develop on a question of what the terms mean?
There's discovery that could be taken from the legislators who were involved in the.
It would be highly irregular
It might
to
be.
depose legislators and ask them what they thought. I can't, maybe you can identify a case where a court has endorsed that approach, but I'd be surprised.
It may be difficult for that discovery to come in, and there may be other discovery that the city has posited, like the state AG's position that we're going to hear about today. That evidence may be
So
probative,
you've mentioned one type of discovery, which is to depose legislators about their intent. Is there any other discovery that you would propose engaging in if this were to be remanded?
Well, even some of the information that has come in on the papers here, which again, the city chides us for mentioning things outside the record, but a fact finder hasn't had access to that record.
So specifically, what would you look to explore in discovery?
Well, I think we would look to explore, for example, the Climate Action Council that has been created by the state legislature, which the city notes references local law 97.
And
in
do
its
what, you would
scoping plan.
depose the members and ask them questions?
Well, not necessarily, but even looking at the scoping plan and looking at how some of the record that, again, the city wants to have it both ways. They say we can't cite that record on appeal, which we're none of this is in the record on appeal because we haven't been able to develop a discovery record below. But the city made a decision here to move to dismiss on the pleadings.
May I
Counsel,
just go
you're-
back? Go ahead.
I just want to say, I think that point's well taken, how the city points to the council's reference to local law 97 in a favorable way to support their argument. But you know, let's say we agree with you on that and we disregard anything that they may have said about local law 97. I'm still struggling with this idea that a question of law, such as field preemption, requires development of a factual record. I don't see those two things as negating one another. So, and by the way, I have to tell you, in all honesty, all the proposed discovery that you just laid out here, hypothetically, not only does it seem highly irregular, which you've heard, I don't understand how that would tend to answer the operative question that we have to answer. So is there something more that you're looking for in this fact-finding?
Well, I really don't think there's something more in the sense that we're not in the position right now to be held to what do we think the factual record would look like. It may be highly irregular, but we have shown, as the first department held, that we're entitled to the opportunity to develop that factual record. I mentioned earlier.
But your argument is about the text. That's your argument. It's about the text. And you
Yes.
say the text should be read this way. Your adversary says the text should be read that way. Strikes me straight up legal question that this court can answer on a motion to dismiss. You're of course correct. There are many things you cannot resolve on a motion to dismiss. But this one seems to be in that category that you can decide on a motion to dismiss. You may not even need to ever look at legislative history if we decide the text is clear.
So I think that the parties' positions in this case show exactly why there is ambiguity that requires looking beyond the language of the statute.
Well, do you disagree that it's a purely legal question? Because I think there was a reference in your brief that it was a mixed question. What's your position on that?
We believe the question of preemption is a legal question, but as the Merck case says, sometimes the court's resolution of a legal question requires the resolution of ancillary factual issues.
And what are those ancillary factual questions here
Those
specifically?
ancillary factual questions here are, what did the legislature mean when it wrote
we
Section
don't-
10
I
and
mean,
Section
That's
11?
That's what
legislative
I'm-
intent.
That's
isn't it?
legislative
And-
intent.
But don't courts generally, maybe always, look to answer that by examining the text and by examining the legislative history as it's set forth in, the documents that are generated as the legislature considers and votes on something?
The text and the legislative history are the first stop, absolutely.
And
But what-
what cases, I know you have Merck, but beyond that, where have we or federal courts, if you want to look at them, gone beyond that and, for example, depose legislators to see what they thought or something like that?
Well, as I mentioned, most of the cases that the city cites, for example, the Garcia case, were decided on summary judgment.
But that-
And and the city could have decided here to answer the complaint, and if it believed that there was no factual record that we could have developed that would have borne at all upon the question of, if this statute is ambiguous, what factual
Counsel-
issues could be used to resolve that ambiguity. They didn't do that.
Can I ask you a question?
Sure.
I'm trying to understand this factual record point that you're making. And if we were to allow you to go back and develop the record that you say needs to be developed, and you adduced evidence, say that this legislation, 97, was going to impact a huge number of building owners in New York City. And not only was it going to be a large number, it was going to seriously impact them. It was going to cost a lot of money to make the upgrades that the legislation requires. Are you saying that in the process of conducting a legal analysis on legislative intent, a court could say, well, this was never intended to be the effect of our law. So therefore, it must be preempted. Is that the process that you envision in this case?
That is a possibility. There may be, and I'm sure there will be, other evidence that the city brings out to try to rebut that. But looking at Local Law 97 here, this is a law that does a number of things. As the city points out, it pre-existed the CLCPA. So we're not arguing that the CLCPA was meant to preempt the entirety of what Local Law 97 had historically done. And so this would be a massive oversight on the New York legislature.
Wasn't the only thing appealed here the motion to dismiss? Was that the
Yes.
only thing in front of the appellate division? So if the appellate division agreed with your reading, let's say, hypothetically, their only option was to deny the motion to dismiss, right?
That's correct.
So it would have to go back.
Yes, it would have to go back, and that's all we're asking for here. We may be back here, next term if the city decides, look, there's no discovery record that you possibly could develop that would decide this question your way. They can move for judgment on the pleadings. They can
I'm
move for
sorry.
summary
That's right.
judgment. But all the first department held correctly was that we, on the pleading, have pled a potential cause of action here for preemption and that we're entitled to go to the next step.
They couldn't find for you, the appellate division. They couldn't enter summary judgment for you. There's no pending summary judgment motion, right?
Correct. Well, this is not a merits appeal. This is a pleading appeal. And that's why it's premature for the court to be decided.
Let me try to ask you something different. Sometimes even when you're chief, it's really hard to get a question in. So let's assume that we agree with you that this is preempted, okay? What I'd like to explore just a tiny bit is what that means practically. So suppose the village of Smithtown decides that it would like to mandate that new homes built in the village of Smithtown have solar roof panels. Could it do that, or is that preempted?
I think it could, because
And would that depend on whether they say that we're doing this to eliminate greenhouse gases, or we're doing this to protect the electrical grid?
no, because the coincidence of the goals of the CLCPA and local legislation is exactly what I think the state wanted to promote. And there's a lot that the city cites from the statute saying we want to work with localities. I think that works
Well,
perfectly.
what if the rollout was more aggressive than what state law contemplated?
I think the only thing that the locality couldn't do is where the state says, we're reserving the right to set these emission limits, and we're going to graduate it over time, we're going to delegate to experts, and we're going to roll out regulations that will deal with this one narrow area. What the locality can't do is say, actually, we're going to make you reduce it more and faster, and we're going to charge penalties for you to do
And so, for example, couldn't say, we're going to mandate that everybody has a solar roof panel within 5 years because that will reduce greenhouse gas emissions below what the state has set?
I don't think we would argue that the CLCPA
Well, then
preempts that.
why not? Then what is preempted then?
The setting of specific reduction targets saying this type of entity or this person bound by this law has to adopt these greenhouse gas emissions limits of X.
So your
when
view
the
is they
state
could
says
require
Y.
specific things to be done as long as they don't set greenhouse emission standards, even if they expressly say the reason we're requiring these specific measures to be taken is because we want greenhouse gases to be lower than what the state has mandated.
I think so. I don't think that the purpose of Local Law 97 is at cross purposes with the CLCPA. I think it's the particular measures that the city has taken to try to do this, which again, I think has turned sort of an incentive-based sort of carrot system that the state saw fit to provide into a stick system where the city is collecting revenue, again, to go into its general coffers with different standards. One of the reasons that the state
Your problem is not really the standards. Your problem is that someone will be penalized for not meeting the locality's standards.
No, I think the problem is the standards because the entire field is preempted. But I think the fact that
I mean, if they made it voluntary and said, we really, really would like you to do this, it would be good for all of us.
I'd have to think about that question. I mean, I think that adding additional incentives to meet standards that are consistent with the standards that are set by the states would present a much closer question.
They said, we'll pay everybody 10% of the income you usually get in a year if you do the following.
I think if the following is consistent with what the CLCPA is doing, then that might be fine. And one of the issue with the different standards at the state level and the local level is really that it takes a long time practically to retrofit or renovate your building to make sure that you have emission limits that are going to comply with
the city provided assistance so that those who are subject to the requirements are able to meet them without too much burden.
I think, again, it would depend on what the requirements are. If the requirements themselves are not consistent with the CLCPAs, and again, for field preemption, it just has to be, the inconsistency is the potential inconsistency of stepping into the field. The state is going to set limits, and if the city sets different limits, that I think would be preempted. I think if the city says, look, the state set these targets, we think the goals are great, we want to provide an extra incentive for New York City buildings to comply with them, we want to provide extra help in complying with them, I think that would present a much closer.
Does that kind of approach require some sort of inconsistency? Because I'm just sitting here thinking, we're all rowing in the same direction, right? We just want to reduce greenhouse gas emissions by a certain amount by a certain date. And there may be differences that ultimately come out. We don't even, well, no, we know what the targets are under the State Act as well. So there's no really, the inconsistency might be in the details at best. And I'm wondering if that's simply not enough to say this is preempted.
This is not a conflict preemption case. It wouldn't be enough if we were bringing a conflict preemption claim, but it's a field preemption claim.
Does that question matter at all in field preemption? That everyone's, as I said, rowing in the same direction, or as they put it, all hands on deck?
It matters in the sense that conceiving of an inconsistency can be illustrative of why the state might have wanted to preempt. It doesn't matter in the sense that, in our view, you have to look at the text, look at Section 10, look at Section 11, and you can see that the state meant to reserve this area of legislation for the state.
Thank you.
See, I'm out of time. Thank you, Your Honors.
Thank you, Your Honors. Philip Levitz for the state amicus. The state's Climate Act does not preempt New York City's Local Law 97 because the state statute creates a broad framework of emissions reduction targets that localities are intended.
Can you respond, counsel, to this argument that she just made, that the city cannot impose or raise the bar, right? Impose more than the state does. That's the conflict.
Well, again, nobody's even arguing for a conflict, and that makes sense because what this state scheme does is it sets out these broad emissions targets, and that's it. There is no detailed regulatory scheme that's intended to apply statewide with which the Local Law 97 could be inconsistent. This scheme looks absolutely nothing.
Is there authority to do that in the future under the statute?
Is there authority to
set those kinds of specific targets in the future?
There is authority to promulgate regulations with more specific.
Isn't that process taking place right now? Aren't they working on the scoping plan?
The scoping plan is published, and there are regulations that have already come out under the statute. There may be more regulations, yes. But none of those regulations, again, nobody's even claimed a conflict between any such regulations and the state statute. And when we're asking, what we're actually dealing with here is a claim of field preemption. So let's talk about what field preemption requires. What field preemption requires is, field preemption applies when a state statute establishes a detailed regulatory scheme demanding statewide uniformity that precludes local regulation.
Can you avoid
that
by kind of offshoring your detailed scheme to another entity? And then say, well, the statute doesn't do
this. Well, the
this.
scoping plan doesn't establish the detailed scheme.
No, but what they're going to do under that, at some point, will that have that type of detail in it? So you've kind of offshored your preemption problem.
I mean, in theory, one might have regulations that provide these more specific details. You might have a conflict preemption assertion at that point. That's an issue that's not before this court.
And you could raise it at that point, couldn't you?
Right, absolutely. Absolutely.
So if, as things evolve, the regulations that are promulgated do give rise to a conflict with provisions or penalties in local law, that could then be addressed in a
At that
more
time.
tailored litigation, yes?
Absolutely.
How about a preemption claim? Could you make that later? A field preemption claim, sorry.
I guess in theory, if you had a claim that the particular regulations were so detailed and were intended to apply on a statewide uniform basis, you might. But that's not going to happen, and I'll tell you why. Because what this statute makes clear is the exact opposite. What the statute is saying is you should have regulations that embrace local efforts.
But if the state
to
had,
support
if the state had preempted the field, right, what would be left for local governments to do in this area? What could they do?
If the state had preempted the field?
Yeah.
I mean, I guess it depended exactly what field they had preempted, but the point is there is no such.
Well, I mean,
I'm sorry.
let's assume for a moment that the field that is preempted is the regulation of greenhouse gases. I think that's what we're talking about.
Okay.
And maybe I'm wrong. Suppose the state has preempted that field. Is there anything, if it's field preempted, that New York City or Smithtown could do to regulate greenhouse gas emissions, different from the state? Could they promulgate their own regulations or statutes?
It would depend what the state statute said and the scope of the state statute. If the state statute said you can't do anything that could affect emission reduction, then no, the locality couldn't. But that's, again, that's the exact
So
opposite
if we
of what
take
the state
her
statute.
hypothetical, let's say the state, I'll make up a number, sets 10. You're trying to get to 10. I'm just making up a number. And the city says, you know, we want it to be even lower. We want it to be at 2, right? But if the state has made clear that they are, as she was saying, staggering or staging the reduction, and they don't want it to go that fast, you would agree that then the state law controls or the reg controls, and the city cannot, or the locality could not seek to go faster than the state's time frame?
The state certainly could set up a scheme where you know, a local government could take a more stringent approach than the state. That happens.
No, I didn't ask that.
Okay, sorry.
I
Maybe
asked
didn't
the
understand
opposite.
question.
If the state made clear that this is the timetable we want this to move on.
Right, then a locality couldn't say, oh, we're going to do something that's going to be an obstacle.
But the
to that.
locality, unless the state said otherwise, whether it's in the statute
Right.
itself or by regulation, the locality could determine how best to achieve those goals, even if it can't go further.
Right.
Do you agree with that?
I think so.
Wouldn't that scenario, if the state put a calendar that said, we'll do this in 10 years, and the locality said, we're going to do it in 2 years, wouldn't that be a question of conflict preemption, not field
Yes, it
preemption?
would. Yes, exactly. Thank you, Your Honor. And again, let's talk about what's actually at issue here, which is field preemption of the statute. They're claiming field preemption by a statute that we already have in place, and there's just absolutely no basis for that. What field preemption looks like, again, is a detailed regulatory scheme we don't have, requiring uniformity statewide, which there's no intention of, and it's the exact opposite intention that's written into the Climate Act. Let me give you an example, as sort of a counterexample here. The kinds of things that this court has found to be field preemptive, the kinds of state statutory schemes that are field preemptive, are things like the alcohol and beverage control law. So, for instance, in the People versus DeJesus case, that's one of our this court's leading cases on field preemption. What the court said when it found field preemption there is that the alcoholic beverage control law preempts the field because it has an extremely detailed regulatory scheme. That scheme imposes its own direct controls at the local level, and there's an express declaration in the statute that the state intends to regulate and control the manufacture, sale, and distribution of alcohol broadly within the state.
So
that is, I'm sorry.
I'd like to interrupt you there if I could. So on field preemption, it seems the statute might not be as detailed. For example, you could have this entity that's going to fill in the details later, but it could express an intent by the state to preempt in the field, nevertheless. Or do you think you need both things?
You could have express preemption.
Let's say there's a statement that says the state intends to preempt the field here. Why isn't that field preemption then?
I mean, I guess you might have to look at the details of the statute as a whole.
Well, would you? That's my question. If the state just said, this is a highly regulated area, we're talking about greenhouse gas emissions, there's no real way to...
I think what you're describing
Can
is...
they say, we intend to preempt this entire field?
Maybe, but I think actually that's better understood as express preemption. It's not what we traditionally think of as field preemption, which is an implied preemption doctrine. And maybe that is a good link to just, if I could make one final
So
point
then
going back
would
to.
their argument on sections 10 and 11 be more of a conflict preemption argument or a field preemption argument?
I mean, the only claim that they have made in this case is a field preemption argument. But let me just go to sections 10 and 11 because, you know, that's the entire statutory basis for their argument, and it just doesn't get them there. And I think Your Honors were getting at some of the reasons why.
But under section 10, let's say, if you know one, could you give me an example of a state entity that could adopt and implement greenhouse gas emissions measures that aren't laws or regulations?
Yes. I think there was discussion of, you know, if you have some sort of state green infrastructure.
Do you know of one?
I'll give you another example that I know of. The Public Service Commission has these clean energy rate orders.
Clean
Could you
energy.
Clean energy rate, what?
Rate
what?
orders. They're rate
Orders.
orders. You might call them laws, you know, so maybe they'd also fit in Section 11, but you might not. They're certainly not as obviously fitting in that category. And that's the idea of Section 10, is it's this belt and suspenders approach of having, you know, recognizing that there's all this existing stuff that the state has been doing in forms like rate orders, like green infrastructure projects, whatever. The State Climate Act didn't come out of nowhere. It came out of a long history of existing state measures to deal with this problem of emissions reduction. And what Section 10 is doing is something different than Section 11. It's saying, look, we know there's stuff the state's already done. We're preserving that. We're making sure that that stays in place to support these ambitious goals that we're now setting in the new statute. Section 11 then adds on something different, which it says we're also making sure we're preserving all, not just state laws, local laws, federal laws, every law. You still have to comply with those because those are going to support these ambitious goals that the state, these ambitious targets that the state set in this statute as well. And we need, again, all hands on deck to get there. You know, if there's any redundancy in Section 11, it's possible you could read it that way. There's nothing particularly unusual about a little redundancy in a statute like this. And a little redundancy actually makes particular sense in this context because we're dealing with this sort of all hands on deck approach where the legislature, the state legislature is intending to make sure that all these different sources of authority and support for these ambitious goals to reduce emissions and protect the state from the devastating effects of climate change are in fact, can be marshaled together.
Thank you.
Thank you.
Your Honors, plaintiffs, they're now conceding that their entire case hinges on this Section 10, Section 11. For the reasons we've already discussed, it doesn't get them there. And there's so many other indications in the statute that the legislature did not intend to preempt local action. And we discussed them at length in our brief. So I'd like to just talk about the standard for remand right now. The plaintiffs are arguing that if there's any dispute, this needs to be remanded for further fact-finding. Multiple cases that we've cited have resolved preemption questions on the motion to dismiss stage. The Garcia case, the Vitor case, the Hertz
What
case.
about the ones that resolve with summary judgment?
There are some cases that have been resolved on summary judgment, but
Is there anything that indicates there was the kind of discovery that's contemplated here in those cases? I don't know.
absolutely not, Your Honor. And I think in a lot of those cases, there were other claims at issue. In some of those cases, there were cross motions for summary
There
judgment.
might be other litigation reasons why it resolves at summary judgment.
Exactly, Your Honor. They've never cited a case that relies on expert testimony. They've never cited a preemption case where any legislators have been deposed. And there's, again,
If the appellate division thought their argument was correct, what was the remedy they could give to the plaintiffs? What could the appellate division do at that point?
to reinstate the claim as it did. But again, for
To
the,
deny your motion to dismiss, so then it goes back to the trial court, right? Trial court can do it once at that point, take motions for summary judgment, it could. So why does we need any further discovery if a court thinks they have a better argument? It's just a denial of your motion to dismiss at that point. There's no other remedy, right?
yeah, but there's no need for remand here because, again, there's nothing to favor their interpretation. And I'd like to just point out that they're arguing that the field that's preempted is greenhouse gas emission limits. And that's a phrase that's not even in Section 10 or 11. They're making up this theory that by reading these provisions in a way that's convenient to them, but it's at odds with what that statute actually says. It's at odds with the legislative findings of the statute. It's at odds with the other language in the statute that repeatedly refers to local action and the state information gathering and collaborating with localities and the shared effort. And it's also at odds with the multiple statements from the state entities implementing the act, which are relevant under Jansen. This court noted in Jansen that the implementing state entities, their views are significant on the question of implied field preemption. So really, everything cuts against plaintiffs here. This court can and should dismiss this claim as a matter of law.
It is an odd, if we could just get back to the appellate division's language, or maybe I've missed something in this opinion. It is an odd resolution, if I can call it that, of the motion to dismiss on the Section 1011 issue, simply saying at the end, one could conclude, as plaintiffs do, that Section 11 applies to local laws other than greenhouse gas emissions reduction measures. But perhaps I missed it. Help me here. I couldn't find anything else in this decision that explained to me how that would be resolved. It's a text-based question. How would one resolve that? It says one could conclude this, but doesn't explain how one would resolve.
We agree, Your Honor, that this is a purely legal question. The court can and should.
Isn't the court in a very difficult position? Let's say the appellate division thought you were wrong. What could they do besides what they did?
They could have actually interpreted the provisions, but they didn't do that.
And that would be giving an opinion on an issue that's not already before them. If it goes back, they move for summary judgment, it comes up again, right? And then they decide if that interpretation is right or wrong. So what they're saying, it seems to me, the appellate division is, you are not, the only issue in front of them is you are not entitled to judgment on a motion to dismiss. That's all they have. So they can't say no because they're right? I guess they could, but they'd almost be giving an advisory opinion on a motion that hasn't come before them yet.
Was their position that I think we see now, which is that there's discovery to be had, was that the position in the appellate division?
Yes, Your Honor. And the discussion of deposing lawmakers came up in the argument before the appellate division as well. And again, there's no need for discovery here.
But then even more odd for the appellate division not to make reference to the fact that it thinks there's a factual issue that has to be determined before they can resolve what looks to me like a plain text reading that only a court can resolve.
We agree it's an odd decision, and again, plaintiffs' interpretation of these provisions, it's really the farthest thing from a clearly evinced preemptive intent, and again, everything else cuts against plaintiffs as well. So we ask this court to reverse and dismiss the implied field preemption claim.
Thank you.
Thank you.